My lord,
Yes.
may I leave to file an appeal without certified copy before yesterday? But there is little bit urgency. The memo of appeal stipulation can meet appear on day after tomorrow, Friday.
Yes.
Is it a tax matter?
Yes.
Friday, my lord. Great.
My lord, under a compelling circumstances, I am mentioning this matter, my lord. In a execution case, bailiff couldn't able to deliver the possession to me, my lord, because of the resistance made by the appellant, against which I file an application under Rule 208 of Civil Rules and Orders, my lord. In spite of deposited the cost, police personnel didn't provide any assistance, against which I came before this Honorable High Court, and Rajsekhar Mantha, Justice Rajsekhar Mantha, pleased to direct the police authority to provide adequate police against that order. Appellant came file a frivolous appeal, my lord.
There is an interim order.
I am praying for inclusion, my lord. Yes, my lord. They state
Then you do one thing. We'll include it in the list.
Civil division application is pending before this court at the instance of the other side.
No, but that civil division application didn't serve to us, my lord. I'm praying for inclusion, my lord.
You give the letter, let us see. Yes, sir.
May I mention a matter, my lord? One the server copy of the order is not reflecting the order which was passed by lordships in the court, my lord. There is some mistake in the operating portion of the order, my lord.
So what is the mistake?
My lord, page 4, last paragraph, my lord. My lord, this submission was not made by me, my lord. It was the lordship direction that in case I invoke the arbitration proceedings, then the findings of the division bench and also the single bench will not be binding. That was your lordship's direction, my lord. It was not my lord, submission.
To be mentioned. Let us see.
I'm grateful, my lord.
My lord, praying for this filing of this appeal without certified copy.
Without certified copy, yes.
My lord, one
Server
more thing
copy
that
is there.
yes, my lord.
Server copy is available.
Server copy is available. My lord, it is against that order which we mentioned day before yesterday regarding that CID.
So they have withdrawn those letters.
They have withdrawn that later. So, my lord, the difficulty now which is arising is that since the petitioner as well as the advocate.
No, you seek for leave to file appeal. You are not a party in that writ petition.
Yes.
So you will have to seek for leave to file appeal. Then filing the application without certified copy. You make such a prayer, we leave.
So additional application for seeking
leave to file appeal has to be filed. Then section 5 also will be there.
Yes, sir.
You file that, we will see.
Great.
And serve copies on.
Yes.
Yes.
Original side daily list, item number 1.
This is my appeal.
Matter has been listed under the caption to be mentioned. It is submitted that in the order dated 5th April 2023, in 2 places, the date has been mentioned as 28th March 2023. However, it should be, the correct date is 29th March 2023. Yes. This mistake be rectified and necessary correction be effected in the order dated 5th April 2023. This order shall form part of the order dated 5th April 2023.
Grateful, my lord.
Item number 2, public interest litigation.
Yes.
My lord, prior to vacation, my lord, summer vacation, there is a direction for serve notice upon the state advocates. But I could not serve, but I have sent the message through WhatsApp message. But I do not.
You have to serve.
Lord, another opportunity we given me, Lord.
Time granted for the learned advocate for the petitioner to serve notice upon the respondent state is extended by 2 weeks from date. Let the matter appear after notice is served on the respondent.
For the information commission, Lord. 2 weeks. 2 weeks.
Item number 3.
2 weeks.
Yes.
Well, I'm appearing virtually, my lord, because of some
I have served.
issue.
They have received it or?
They have received, my lord. Mr. Jhunjhunwala had called me in the morning.
But I'm appearing virtually, Your Lordship, because
Oh,
of
is
some health issue.
Yes,
Some
Pradeep.
health issue, my lord. Because of that, I'm appearing virtually. My lord, in this matter, there's a delay of 200 days, my lord. That may be condoned, and I am requesting if the matter may be fixed on 30th or any date subsequently, my lord. Mr. J.P. Khaitan is leading me in the matter, my lord, my senior.
Heard Mr. Amit Sharma.
My lord, I am appearing.
Mr. Vipul Gundali and Mr. Amit Sharma, learned advocate for appearing for the appellant revenue, and Mr. Pratyush Jhunjhunwala, learned advocate for the respondent SSC. There is a delay of 204 days in filing the appeal. The reasons assigned for not preferring the appeal within the period of limitation is convincing, and accordingly, the application is allowed and the delay in filing the appeal is condoned. Let the appeal be listed on so and so date, and the name of Mr. Pratyush Jhunjhunwala be printed in the cost list for the respondent.
I'm grateful, Your Lordship. I'm grateful.
Monthly list, item number 31.
My lord, I am appearing in this matter, my lord. This is that broker matter, my lord. Mr. Ashok Bhaumik was appearing in the matter on the last occasion when this matter was heard. I had made extensive submissions. My lord, thereafter, my lord, he was supposed to actually address
Yes,
the court
that
today.
is that customs broker.
Yes, my lord. Yes, my lord.
And where is he? Is not attending court today.
I had also, my lord had directed us to give the volumes. My lord, I have prepared the documents where I have given all the orders in originals as a both.
And you serve one set of
We have already served
Already
upon
served.
them. We have already served upon them. In fact, before vacation, we had served the copies to them.
already. We have heard Mr. Vipul Gundalia and an advocate appearing for the appellant revenue. In terms of the directions issued earlier, a compilation containing all relevant documents
3 volumes.
in
my
3
lord.
volumes has been filed. The same is taken on record. None appears for the respondent. List on so and so date.
I'm grateful. my lord.
Item number 32.
I'm for the appellant. Last occasion, my lord had directed me to serve the copy through mail because my learned friend was not appearing. Today, he is appearing, I will be serving the copy to him.
My lord, the service has not been completed. We've only received the memo of appeal.
No, my lord, that was through mail, my lord. Today, as he is appearing, my lord, I will be physically serving the copies to him.
We have heard Mr. Tilak Mitrol, standing counsel for the appellant. Mr. Kejriwal accepts notice for the respondent. Let the copy of the stay application be served on the learned advocate for the respondent, and the matter be listed for admission on so and so date.
Grateful, my lord.
Item number 33 with 34.
For the appellant, my lord, 33 and 34.
What shall we do? Pass over. Sir? Calcutta electricity supply.
Pure question of law is involved in this matter. Under section 126, is applicable in a non-consumer or not? Because the assessment has been done, who is not the consumer at all. That is the point. Only one short point is involved.
All right, pass over.
Item number 35. And for the petitioner, appellant petitioner, there are 2 appeals. In one, I am the appellant, and in the other, my learned friend is appellant. My lord, Mr. Soumya Majumdar is not available now or today. So I'm praying for not today, my lord.
All right, item 34 and 35.
My lord, making not this week only, my lord.
Not this week. As prayed for by the learned advocate for the appellant. Not this week. Okay.
Item number 37.
37, my lord, for the state, my lord.
State.
It's one state. Lordship,
Ah.
I appear on behalf of the appellant.
Wait. Sit down for some time. Now you had impugned the show cause notices,
Yes, your lordship.
saying that he is not he is only an
In the writ
accountant.
petition. In the writ petition and thereafter also the impugned order.
No, you should have taken liberty from the writ court to agitate this issue as a preliminary point before the concerned authority. Why did you invite a finding here? See, your case is, though your designation was manager, finance, chief accounts officer, etc., you are an ordinary accountant.
Yeah.
You do not perform any managerial functions. You have no decision-making power, etc. This issue you should agitate because you are one of the notices. Where is the show cause notice? Who appeared for the PF organization?
Lordship, Mr. Prasad.
Prasad appeared. Have you served on him?
Yes, your lordship. Lordship was pleased to restore the interim order, which was already subsisting during the writ petition, and also invited affidavits from the parties. We have not received any affidavits till date.
On what date interim order was granted?
10th of April 2023 by your lordships.
Sir, order sheet.
Lordship, may I hand up?
Then let them file their affidavit.
Yes, sir. Kindly.
We have heard so and so. By order dated 10th April 2023, while granting an interim order in favor of the appellant, direction was issued to the respondents to file their affidavits within a period of 3 weeks from the said date, and reply, if any, within a period of 2 weeks thereafter. Till date, affidavit has not been filed by the respondent. The time for filing affidavits by the respondents is extended by 4 weeks from date. Reply, if any, within 2 weeks thereafter. List the matter. After 7 weeks, you give a date.
My lord.
You inform Mr. Prasad.
Yes, my lord. I think we could not locate the advocate on record of the special officer, but we shall make endeavors and.
Yes, please.
Item number 38.
Your Lordship,
For the appellant petitioner, my lord.
Mr. Devanjan Mukherjee is appearing on behalf of the CSC, Your Lordship. He is presently on his legs before court number 9.
He is held up there.
Your Lordship, for this reason, praying for a day's accommodation, Your Lordship.
Short fact is that, my lord, petitioner in the month of July 2022 found that 6 additional meters has been installed in his premises, in his meter room. He made a representation to the CSC for removal of such meters. CSC says, no, unless directed by this court, we have nothing to do. We filed this petition. CSC in their opposition stated that out of 6 meters, 1 meter they did not install. They do not know how the meter has been there. And regarding other 5 meters, they are saying that those persons have some establishment in the premises, but practically nothing is there. And they also admitted that separate meter room is there in premises number 81, where those persons are resided. But surprisingly, they are reluctant to remove the meters only on the score that it is the market area. So in case of market area, they cannot remove the meters. That is the point. And learned judge, after taking into consideration, saying that the picture shows the meter room is situated in a place which appears that it may be a juncture of 2 premises. But CSC admitted in the opposition that the meter room is situated in our premises. There's a question of situation of meter room in a place.
But how to adjudicate this disputed question of fact? Suppose you are the owner of door number 81, premises number
81 by 1.
81 bar 1.
81 by 1, lordship.
Bar 1. And these meters are established there. And the other people are either tenants or co-owners, maybe. Probably for the sake of convenience, a single place is chosen where the main cable will come and it is distributed to meters. And if you say that has to be relocated, it is basically a problem between yourself and the tenant, or yourself and the other co-owners of the premises or adjoining owners. But how to adjudicate that in a writ petition?
My only point is that when
you could have gone to the ombudsman.
There's a dispute that those meters belongs to premises number 81. The electricity.
No, the learned writ court in page 132, last paragraph. Page 132.
My lord.
It transpires from the submission of the parties and materials on record annexed that there is a dispute between the parties as regards whether premises 81 and 81 bar 1 are structurally the same premises and merely separate SSC numbers have been allotted by the corporation, or the same are distinct and different premises, even on structural consideration. The other objection taken by the petitioner, the rent bill produced by respondent number 7, pertains to a different premises than 81 bar 1, which belongs to the petitioner. However, from the documents on record, no case has been made out by any of the parties that there are separate premises in the same neighborhood. That apart, technical question as to whether true premises are structurally the same cannot be adjudicated within the scope of the present writ petition without taking evidence. Such exercise would be meaningless for the present purpose, and CESC has placed photograph on record by annexing the same. Their affidavit shows that the existing meters, including meter, are situated in a position which is exactly in the middle between two visible different premises.
Yes, that is my point, my lord.
No.
Here,
You should not have come to the writ court. You should have asked for an inspection to be done.
my lord, kindly direct any advocate commissioner to make an inspection. We bear the cost.
Let the engineers of the licensee, CESC, they can inspect. Then you show your documents. But essentially, if you file a civil suit and say that this premises with these boundaries and this wall is your premises number 81/1. This is distinct from 81. So nobody can install any meter in this section of the building, which is my premises.
Only one submission, my lord. Admittedly, there is a separate meter room in 81 and
But
81.
we can't adjudicate that in a writ petition.
It is the admitted fact, my lord. They are admitted that
What we can do is we can give you liberty to produce documents before the CESC stating that it is an individual premises.
Lordship,
If it is there, let them consider.
lordship.
We can't adjudicate. We will dismiss the appeal, but that liberty will always be there. This intra-court appeal by the writ petitioner is directed against the order dated 14th March 2023 in WPO 2569 of 2022. The grievance of the appellant writ petitioner was that 6 electronic meters have been installed in his premises, bearing premises number 81/1, Madan Mohan Burman Street, Kolkata 7. And he has sought for a direction upon the CESC Limited to remove the meters other than the meter which has been installed for premises number 81/1 belonging to the appellant writ petitioner. The learned writ court, in our view, rightly dismissed the writ petition on the ground that the question as to whether two premises are structurally the same cannot be adjudicated in a writ petition without taking evidence. If according to the appellant writ petitioner, the meters cannot be installed in portion of premises number 81/1, it is for the appellant writ petitioner to establish the same before the appropriate forum. In our prime facie view, the civil court will be the appropriate forum before which the appellant can seek to establish his contention that the premises number 81/1 is a distinct premises, and the place where the meters have been installed, 6 meters have been installed, is within premises number 81/1. Without resorting to such remedy, the appellant had approached the wrong forum by filing a writ petition. However, since matters relate to disputed questions of fact, the same cannot be adjudicated in a writ petition. And if so advised, the appellant is at liberty to approach the CESC Limited with the documents of title and other documents to show that the area where the meters are installed are exclusively within premises number 81/1. If such request is made by the appellant, it is open to the respondent CESC Limited to consider the same in accordance with the law. With the above observation, the appeal stands dismissed. Next.
Item number 39.
I am for the respondent. Now, as interim measure, Lordship was pleased to direct them to deposit 1 crore with the port authority. They have done so. Now, there was also a direction to file affidavit in opposition by the authority. Now, it could not be done due to vacation. I am seeking 2 weeks extension to file the opposition. And if they want to file reply, and thereafter Lordship can take up them.
2 weeks thereafter, Lordship. 2 weeks, so 3 weeks, 1 week. And the interim order to continue on a lot. It was a conditional order. We have complied with the condition.
We have heard the learned advocates for the parties. The direction issued in the order dated 26th April 2023 has been complied with by the appellant, and a sum of rupees 1 crore has been deposited by the appellant with the Kolkata Port Trust within the time stipulated. Therefore, the interim order already granted shall continue. The time for filing affidavit in opposition by the respondent Kolkata Port Trust is extended by 3 weeks from date. Reply, if any, within 2 weeks thereafter. List the matter on so and so date.
Obliged. Interim order, the time may be given, or the interim order.
Otherwise,
Continue.
no, we'll give a date. We are going to give a date. We are not adjourning 12 weeks, 15 weeks. List on so and so date. If it doesn't come, please mention.
Interim order to continue till that date.
That will be one day. If it is not taken up, it will be taken up in the next
Suppose
day.
the bench is not sitting.
Lordship.
And can something be done? Some mediation, nothing can be done.
No.
Because you are not recognizing him as a
No. He's a rank trespass.
They have lingered the matter. No, for others, they have a policy, but for my client, they don't have a policy. Anyway.
Item number 40.
Actually, in this matter, appear for the appellant.
Lord, I am for the respondents, my lord. Before my learned senior starts, my lord, this is a group 3 appeal, my lord. Your lordships do not have the determination anymore, my lord.
Well, we are in the understanding, my lord, there is intercourt appeal, my lord. Your lordship have the jurisdiction. That is why it is filed.
I don't know.
My lord,
Is it correct? No. Even if it is an intra-court appeal, the determination will be determined by the original determination. So, therefore, since the appeal, since this intra-court appeal arises out of a matter under Group 3, the appeal be listed before the appropriate division bench dealing with appeals arising out of orders passed in Group 3 matters.
Item number 41.
Wait, please, my lord.
Who will appear for the respondent? 148.
My lord. The appeal is on a very short point relating to the violation of principles of natural justice. But before I start, my lord, may I just point out, my lord, I've been instructed in the morning today that the reassessment order has been passed during the pendency of my writ.
To bring it on record as a supplement.
My lord, I should bring it on.
You got a copy of that order?
No, my lord, I just got an instruction right. No,
and on what ground the learned report?
My lord, the issue is very small, my lord. 148A(b) notice was given. I gave my reply. I asked, please give me the documents you are relying upon. 148AD order was passed without giving me any documents. I filed the writ petition. The learned trial court, my lord, acknowledged and appreciated the fact that there is a violation of natural justice. But the trial court held that since now 148AD order is passed, so information is already there in the 148AD order. So you treat that as the information. No, that I am aggrieved because
no, he will treat that as an information.
No, that is not the information.
But that will be treated as a 148A.
B. That is the direction of the learned single judge.
The order of 148AD at page 61.
No. The 148AD order to be construed as an 148AB notice, and he will give an objection to that, and thereafter you have to adjudicate the matter.
May I sub? The learned single judge, my submission before lordship. The learned single judge, opined that the order passed under section 148AD. That should be treated as order under section 148AB.
Yes.
All information has been given in the 148AD order. Now, my learned friend did not make any objection to that 148AD order that is treated as 148AB. He is simply sitting praying an adjournment in the meantime reassessment order. Not only that, in this matter, they have committed fraud. The Rukas, we have the report to that effect. They have Milord, done Milord unaccounted money in the form of rukas. That Milord search and seizure has been done. Milord, 3 or 4%, Milord, the statement has been taken. They had admitted that Milord for the Milord benefit of agency and for the benefit of Milord some amount, Milord, they have done that. Milord, this is the Milord report, Milord, of the Milord total investigation. And Milord,
No, see, this direction, the revenue has not filed any appeal.
Milord, we are Milord accepting.
So, in the interim, if an assessment order has been passed, then this order becomes, you can't make this order unworkable.
Milord, not because your lordship kindly will not hear me. Milord, before
On what date assessment order has been passed?
No, Milord, not assessment order passed. The order under section 148 AD has been passed because the learned court directed to Milord make them Milord objection within period of 10 days. They did not. Thereafter, Milord, 148 AD order has been passed. Milord, thereafter, Milord, they will get Milord 3 opportunities because Milord, the section says they will get the Milord opportunity of show cause. Thereafter, show cause notice there will be served. Thereafter, Milord, draft assessment order will be served. Thereafter, Milord, assessment proceeding. Not only that, Milord, I have Milord 3 judgments of Milord different high court. Milord, the court says Milord, when Milord the accommodation entries has been made and the Milord fraud has been committed, Milord, the Milord assessee got Milord ample.
No, that's on the merits of the matter.
Milord,
the red court has not gone into the merits.
Kindly see the impugned order at page 94, 3 lines.
Yes.
At page 94, my lord, the first paragraph in the middle, fact remains. Fact remains that though at the time of passing the impugned order under section 148 AD, the materials which were available to the assessing officer, though through inside portal, has been disclosed in the order under section 148 AD, that they same should have been supplied to the petitioner. Now it should be treated as information to the petitioner for the purpose of giving additional response. My lord, pausing here for a moment, my lord will kindly take page 64, that is the 148 AD order, where the information which the trial court was of the opinion is given to the assessee. Page 64, the 148 AD order starts from page 60. At page 64, there's a table. My lord will kindly see the 3rd column annexure and then the PDF page number. My lord, this cannot be the information on which I can reply. They have to give me this PDF number.
Why did you respond? You got an order in your favor and you could have responded saying that no. Before I file my additional response, please give me these documents.
But my lord, that finding the trial court said treat this as the information. Well, this cannot be the information. I need that PDF document.
Well, that is the only marking. Milord AKK. Milord AKK means Milord Anil Kumar Kesera. Milord the Anil Kumar Kesera from the Milord position of Anil Kumar Kesera document has been seized. Now that document has been marked KK1, KK2, KK3, KK. That is not that Milord something Milord anything that not supplied to him.
He is a third party to the search.
My lord,
Anil Kumar Kes 2, 3 appeals are there. Anil Kumar Keseras and Milord, this is Milord.
Well, I am a third party to the search. I have not been searched.
Harish Kumar Singhania.
Nobody has been searched.
Harish Kumar Singhania, Milord, associated with Milord Anil Kumar Keseras.
Correct. So, admittedly, for Anil Kumar Singhania, there was no search.
No search.
You are trying to fix him based upon documents referred from Anil Kumar Kesera.
Milord, Anil Kumar Kesera also Milord make statement.
So, what we will do is, we will keep this order in the writ petition intact. We will direct them to furnish copies of the statements which were recorded from Anil Kumar Kesera. Suppose he says, sir, I'd like to cross-examine.
My lord. My lord.
Milord, my respectful submission before Lordship, Milord, that.
No, if you want to fix him properly.
Milord, may I submit before your Lordship kindly allow me Milord to place the Milord the report of the Milord investigation authority.
The merits of the matter. That will be going into the merits of.
Milord, they have got the opportunity to file their objection. Milord, in the objection they can say kindly.
No, in the objection what they will say is we have not been supplied with the documents. Please supply
that they have not said.
Yeah, we have said page 59.
Not only that.
No, what do you want perusal or you want copies?
We need the whole copies, my lord. Whatever relied upon documents should be given to us. If they are relying upon anything against me, they should serve me that so that we can make a proper reply. Otherwise, this becomes a mechanical exercise, my
lord. Kindly see Milord page 64.
Because in the tabular column,
My lord,
under the heading borrowed group by,
my lord,
the appellant's name is there.
my lord.
Not only that, the amount is 25 lakhs.
This is on the basis.
The investigation report says they have suppressed 2 zeros. That is not 25 lakhs. That is 25 crores. Now,
They have to give us that report.
they are trying to stall the assistance proceeding. In that way, no information
What we'll do
is
is,
having to them.
we will keep this order intact
My lord,
and we will direct the assessing officer to permit perusal of the annexures which have been referred
my lord,
in his office.
my lord,
You take notes.
my lord.
Based on that,
My lord,
give
that
your
is
reply.
sufficient, my lord.
Because he is an associate.
My lord.
Huh?
No, that is the allegation.
Allegation. So
Yes.
therefore, question of putting him in the dock, etc., will weaken your case.
Yes, my lord.
He may say
So if I
something
get the
more.
perusal of the relied upon documents, I can make notes and make a reply.
You let him peruse those documents
My lord.
and make his.
It is submission. It is not that they have not the information. They have trying to
They have all information.
they have trying to stall the assessment proceedings.
No, we
Because
will fix a time frame.
20,000 crores rupees has been frauded. And one of the matter, Kalichar matter, Lane single judge passed an order for ED direction to ED to take
Here also you
investigation.
can forward
Malat,
the file to ED.
every is cases groups they have committed fraud with the department in undisclosed income. Your lordship kindly once my satisfaction kindly see one.
You are trying to prejudice us. Huh? What is this judgment?
This is only reported. May I paragraph number 7, Milord.
No, this was under this in a stage of AB.
No, not only Milord A, B, Milord. Thereafter, Milord A, D, I, and consequent notice under section 140 on the ground that order under section 148 AD had been passed without considering the reply filed by the assessee raising objection of the notice issued under section 148 AB. What this on the court says. The relied upon 3 judgment of the different high court the honorable High Court of Punjab and Haryana ultimately says thus in paragraph number 10.
See, para 10, they have said by now it is well settled that there is vexed distinction between jurisdictional error and error of law and fact within jurisdiction. If there is an error of fact, that cannot be adjudicated here. But if there is a jurisdictional error,
here is no jurisdictional error.
Natural justice violation, my lord.
Please come.
My lord's own judgment in Krishna tissues.
In this order, in this situation, the second order under section 148 AD has been passed. That is not before your lordship.
That we will bring it.
Kindly see para 6, my lord. At para 6, internal page 7 in the middle, the fundamental error committed by the assessing officer in not providing the third party information, which was the basis of issuance of the show cause notice, apart from making available those third parties for cross-examination by the assessee when the statements recorded by them have been relied upon for issuance of the show cause notice, more particularly in spite of specific requests made by the assessee in this regard. That apart, after passing of the order under section 148, the assessing officer could not have stated that if the assessee wishes to cross-verify or cross-examine the evidence, they may do so after taking prior appointment from him. In the light of that, but this is a well-settled issue that at least
not that he has not given on information. 148D order specifically stated his entry in the accommodation. Now the order passed by the 148AD. Second 148 AD order after the order passed on line single judge. Your lordship kindly see some pages, page 7 of the order. Here this case is that in the Rukas they have suppressed 2 zeros. They have given 20 crores unaccounted money, my lord.
All right. Now, this order was passed on 27th April 2023.
My lord.
Order in the writ petition.
Yes.
And the learned writ court granted 10 days time.
My lord, I don't know, my lord, the appeal also has been filed, my lord, after 10 days.
We had filed within the
My
10
lord,
days
appeal
and the
also
vacation
has
was
been
there.
filed, my lord, after, not only that, my lord, here they have not made, my lord, approach before the my lord, assessing officer, and my lord, my copy, my lord, no date had been given when the appeal filed.
Appeal was filed on 8th of May.
Like 8th of May.
It is within 10 days.
And my lord, the letter after
You
the
give that AD order, second AD order.
My lord, second, my lord, I have got my lord, information just yesterday, my lord, evening. My lord, that is my lord, AD order. My lord, that is dated, my lord, 18/5/2023.
Tell them.
Yes, Mr. Bhattacharyya, where was the occasion to pass a fresh order under section 148 AD?
My lord, because my lord, they have, my lord, in the my lord,
Not filed any response.
they have filed response.
Yes.
They have filed response. They said, my lord, we have filed appeal. Therefore, my lord, you did not
That
pass
is not
any
a
order.
response on merits. That's a.
My lord, that is, my lord, another issue, my lord, but they have
Because
filed my lord,
learned judge
response to the, my
says
lord,
that order will stand revived.
Kindly come to page 94, last two
order,
lines.
my lord, order.
The
Yes, my lord.
earlier order would stand revived. There was no occasion
My lord,
to pass a fresh order.
I understand. But my lord, the phrase 148 AD order, my lord, the information is given in detail. My lord, they have taken, my lord, several accommodation entries. In my lord, chart, my lord, that had been given.
The assessee has furnished response on 10/5/23, which is reproduced. In compliance of this notice submitted, we have filed an appeal against the order of the Hon'ble Calcutta High Court against writ petition wide appeal number 866 with the so and so. You could have waited for 1 week at least.
Internal page 7 million of that order, million, the beneficiaries of the appellant is million there. And million, you'll have to kindly see the amount. And 2 zeros has been left. You'll also know that in the Sati Bajaj case, you'll also specifically held that if fraud has been committed, nothing will help them.
But we are not examining the matter on merits now. We are on procedure.
They have,
for
question is before a lordship
a
that
proper reply, at least I have to have the documents in hand.
in the show cause stage, my respective submission.
What he could have done is, after he received this response on 10th of May, saying that they have said we have preferred an appeal. He could have said, if no orders are passed, no order is passed by the appellate court, granting an interim order or anything, within 10 days, I will be constrained to proceed further. And he could have said automatically, because this 10th May is not a response on merits. So you need not have done anything. Just left it. And the 148 AD order, which was impugned in the writ petition, stands revived.
My respectful submission before lordship, the 148 AD order is not the assessment order. They will get at least 3 chances. They will get at least 3 chances to controvert the information given in the 148 AD order. This is premature stage. We want even come to the read court also, because this is a notice stage. The assessing officer.
But then there is a direction issued by the writ court that within the time limit of 10 days, they preferred the appeal. After you issued the show cause notice, they sent a reply saying, sir, I filed an appeal, and the appeal will be taken up by the division bench.
We have come before my lord at the earliest. There was a vacation, and this is the first week after reopening. We are before my lord. At the earliest, we are before my lord. We cannot have come before more early.
Not only that, the order has been passed, the order has been passed, when a 148 AD order has been passed on 31st March 2023. The order.
First order.
First order, 31st March 2023.
Challenge that.
Thereafter, my lord, they have come before the read court. When they have come before the read court, long thereafter.
They filed the writ petition in April.
What long ago?
No date has been given in my petition.
No date has been given. A date on which it was affirmed is not there.
But here, my lord, before your lordship, my lord, kindly, my lord, consider one thing, my lord. My lord, it is a, my lord, 148 AB notice. Notice, my lord, only what the assessing officer is saying. My lord, assessing officer says, see, this is the information. You have, my lord, accommodated this. Kindly reply. Thereafter, my lord, they come before the read court. Read court, he said, my lord, no information is given. Now, read court says, yes, information has been given in the 148 AD order. And order itself says that, my lord, there is a accommodation entry. Their applicant name is there. My lord, on the basis of that, they should, my lord, file objection saying that.
Let them file objection to the 148 AD reasons. You give him one opportunity to examine those statements. No, we will say no cross-examination. You examine the statement. Within a week, he will be permitted to examine. 1 week for his reply. You pass a fresh AD on. Okay, come. This intra-court appeal by the writ petitioner is directed against the order dated 27th April 2023 in WPO 867 of 2023. The said writ petition, the appellant had challenged the order passed by the respondent dated 31st March 2023 under section 148 capital A within bracket small d of the Income Tax Act 1961 within bracket the Act for the assessment year 2019-20 on the sole ground of violation of principles of natural justice. Since the petitioner was not furnished with the material, the petitioner did not have access to the material based on which the show cause notice under section 148 capital A within bracket small b of the Act was issued. The learned single bench, after taking note of the submissions on either side, has recorded that after the materials based on which the reopening was proposed finds place in the order passed under section 148A within bracket D within bracket impugned order in the writ petition bracket close, and has also held that the same should have been disclosed to the appellant prior to passing such an order. In the light of the said finding, the learned writ court directed the order dated 31st March 2023 passed under section 148 capital A within bracket small d of the Act to be treated as a notice, and the appellant was granted liberty to file additional response within a period of 10 days from the date of the order passed in the writ petition. The appellant, being aggrieved by the said order, had filed the appeal before this court on 8th of May 2023, well before the expiry of the 10-day period stipulated by the learned writ court. However, due to intervening summer vacation, the appeal was not listed, and it has been listed today for hearing before this bench, before this division bench. The learned senior standing counsel for the respondent would vehemently contend that in spite of liberty being granted to file an additional response, the appellant did not comply with the direction and merely stated that appeal has been filed against the order in the writ petition. The assessing officer, on taking into consideration the information which was already on record, has passed fresh orders under section 148 capital A within bracket small d of the Act dated 18/5/2023. Though this order did not form part of the appeal papers, it has been placed before us by the revenue, which is taken on record, and the correctness of the said order dated 18/5/2023 is also examined in this appeal. The learned senior standing counsel for the appellant placed reliance on the decision of the Division Bench of the High Court of Punjab and Haryana in Krishna.
Not appeal, my lord, we are the respondent in this matter.
Respondent revenue relied upon the decision of the High Court of Punjab and Haryana in Krishna Goyal versus Principal Commissioner of Income Tax 2022 140 taxman.com 136 within bracket P&H to contend that the writ court ought not to interfere at an intermediate stage. But in exercise of its power under Article 226 of the Constitution. In the said decision in paragraph 10, the Honorable Division Bench has pointed out that it is a settled position of law. Pointed out that it is well settled that there is vexed distinction between jurisdictional error and error of law/fact within jurisdiction. And for rectification of errors, statutory remedy has been provided. In the instant case, the appellant's contention is that there has been violation of principles of natural justice, which would encompass a jurisdictional error. Therefore, the court is required to see whether there was violation of principles of natural justice. We need not labor much to come to a conclusion, as the learned writ court itself has rendered a finding that the information ought to have been disclosed to the appellant along with the notice, show cause notice issued under section 148 capital A within bracket small b of the Act. Therefore, when there is violation of principles of natural justice, there is no bar for entertaining a challenge to the order passed under section 148 capital A within bracket small d of the Act under Article 226 of the Constitution of India. Full stop. We are conscious of the fact that in a writ proceedings, the merits of the characters of the order passed by the assessing officer under section 148 AD cannot be questioned. Or in other words, it is the decision-making process which can be subject matter of judicial review, not the decision itself. Considering the full stop. The learned standing counsel for the revenue would vehemently contend that the case of the case on hand is a clear case of fraud, and substantial sums of money have been and substantial revenues involved in the matter, and statements have been recorded, which will clearly show that a unique deceptive method of coding the amount of transaction has been adopted and fraud has been played. In our view, this issue cannot be adjudicated in the present proceedings, as we are not dealing with the merits of the matter, and as already pointed out, the same cannot be adjudicated in a writ petition. And if there is a challenge to the order on merits, it goes without saying that the assessee should avail the statutory remedies available under the Income Tax Act. Since the learned writ court was satisfied that there has been violation of principles of natural justice, to which finding we also concur, we are of the view that the appellant should be afforded an opportunity to put forth their additional response to the allegations which have been set out in the order passed under section 148 capital A within bracket small d of the Act dated 31st March 2023. The learned advocate appearing for the appellant assessee pointed out that in the said order, certain information has been mentioned in a tabulated format in page 5 of the said order, and the appellant has not been furnished with the copies of those statements. We find from page 5 of the order dated 31st March 2023, a working table with respect to cash loan transactions of the assessee has been shown. and the name of the assessee figures in the said tabulated statement. However, there are certain statements of other persons which have been recorded, which have been marked with the abbreviation within inverted comma AKK, full stop. Admittedly, the appellant has not been furnished with the said statements, which appear to be the basis for initiating
That is my response.
for reopening of the proceeding.
KK2, KK10, KK4, not the all statement, some scissor material, some note, some diary, some bills.
Statement / seized material marked with the abbreviation AKK. In the light of the above, we issue the following direction, stipulating strict timelines within which full stop. In the result, the appeal stands disposed of by directing the assessing officer to give permission to the authorized representative of the assessee to peruse the annexures which have been marked with the abbreviation AKK and take notes, and such opportunity be given within a period of 1 week from the date of receipt of the server copy of this order. After perusal of those documents / seized materials / bills / memos, etc., the assessee is directed to submit their additional response within 10 days from the date on which the perusal is completed. Thereafter, the assessing officer shall consider the additional response and the materials that the assessee may place before him along with the response and pass fresh orders under section 148 capital A within bracket small d of the Act on merits and in accordance with the law. In the light of the above direction, the orders which have been passed by the assessing officer under section 148 capital A within bracket D dated 18th of May 2023 stands set aside.
18th May 2023 in respect of second appeal. That is
Vishwanath second.
That is
And what is your date?
My lord, this is the
in all matters, subsequent order has been passed. Only I have 1 minute order.
Orders date
Your
we do
lordship
not have, my lord.
Your lordship kindly did not make any date. Your lordship kindly make if subsequent order
Under 148 AD.
Under 148.
Subsequent fresh orders passed under section 148 AD on 18/5/2023 or any other date.
My lord. The next two matters are identical with the dates which I have just handed over, my lord. The next two matters.
It can be a common
My lord,
order.
it can be a common order for all the three
The
matters.
three appeals common orders.
Only SEC will get the information in respect of their involvement. In the your lordship kindly says only one word. Your lordship says they will get the opportunity to go through the annexure. Only relating to the case of the SEC. Because here thousands of document has been said.
So whatever is relied upon against the SEC.
Needless to state that the assessee should be given opportunity to peruse the documents relatable and referable to the assessee alone.
I'm grateful, my lord.
This one you give it to someone. This one you give.
Will you kindly mention that this order will be applicable to 42 and 43 also, because my lord has
No, we'll give a common order.
My lord, my lord. I'm grateful, my lord.
Item number 44.
A diploma. There is a group of matters. Seventh, no? Dev Nandi.
My lord, item number 44, my lord, in mat number 556 of 2019, this is the leading matter, my lord, in the matter of Samput Narayan Mukherjee. Mr. Maiti is arguing in this matter, my
Where
lord.
is he?
Lord, he is engaged in other court. If your lordship kindly make some. My lord, your matter has been heard at length, my lord.
44 to 49,
44 to
it's the same
44.
group.
And based on this order of passed by the learned Singh.
On what date we heard the matter last?
This was last heard on the 6th of September, 2022. It was heard on various dates, Miller. The last date was 6th of September.
Yes, the original file is available.
Original file is available. But your lordship kindly take it on next week, my lord. I am saying only one thing, my lord. Your lordship has passed in the meantime various decisions. I want to show before your lordship that decision.
No, you just recollect what is this matter?
My lord, the issue before your lordship whether cross examination should be given under section 138B of the Customs Act. The authority concerned had passed the order and he has given why he has not given the opportunity of cross examination. That was given. But that was.
But the senior counsel was appearing.
Yes, Millard. Actually, there is one writ appeal which is pending. Millard, the others are statutory appeals from the tribunal's order. Millard, what happened was a show cause notice had been issued to 14 persons. That adjudication order was passed. One person filed a writ petition. 7 individuals filed statutory appeals before the SESTAT. Now, Millard, the person who filed the writ petition before the writ court, he succeeded on the point that cross-examination ought to have been allowed. And the matter was remanded. Now, this order was followed by the SESTAT and the matters which were pending before the SESTAT, those 7 appeals, those got remanded for de novo adjudication. Against that order, they have
heard this.
You're unnecessarily delaying the matter.
Only, my lord, I am praying only 3 days next Monday, my lord.
No. See how much of time has been lost.
Yes, my lord.
The writ petition was filed then. SESTAT has passed an order and appeal is pending to 2019. If you had accepted the order and allowed them cross-examination, because we remember senior counsel's contention was
yes,
all the decisions which you had referred are not relatable to the facts of the.
Yes. No, I will show, my lord, from the facts that
we can do one thing,
my lord.
We can leave the legal question open.
Absolutely.
We leave the legal question open. Within 2 weeks, you allow them cross-examination. Why this appeal should be hanging here? Now, he is benefited by that. Your adjudication is yet to be completed. So, we will say that no useful purpose would be served because there are a batch of 7 cases.
Yes.
And following the order in the writ court, tribunal has also remanded. Matter seized off by the adjudicating authority. In the meantime, this issue has come up. So we will say whatever is the grounds, legal submissions made, and the question of law is left open. And the decision of the writ court shall not be treated as a precedent. And considering these facts, we direct the adjudicating authority to implement that is the best course of it. You finish them off.
Yes.
Well, the prayer for cross-examination would stand allowed in that event.
Yes,
that was my only prayer. That was my only prayer.
Cross-examination will allow. But
no difficulty
that
there.
order will not be a precedent.
Very well, Millard, no difficulty there. Because I had succeeded before the tribunal on the point that cross-examination should have been allowed.
Be an order of the court.
My lord, the thing is that then I will have to place the case. Then I will have to place my case, my lord. The thing is that, my lord, it is now in each and every case, when the cross-examination has not been allowed, they are coming to the writ court, violation of natural justice. Why they are not preparing the statutory appeal, my lord?
There are judgments this way and that way.
Yes.
There are a lot of judgments which have dismissed the writ petition.
My submission before your lordship would be, when the inquiry has been done and the statement has been obtained from the witnesses, can it be considered an affidavit in chief? Examination in chief. Then the question will come, my lord, cross-examination. When I am not considering this statement, the adjudicating authority, when relying upon the statement, whether that can be considered that examination in chief. If that is examination in chief, then the next question will come, cross-examination. And thereafter, my lord, then I have the opportunity for recross them. So, my lord, your lordship has to think about this aspect also. And that can be done only in the criminal proceedings, my lord. It is the preponderance of probability. It is the civil consequence, my lord. It is not at all I am sending him to jail. It is not the prosecution case. And here, my lord, the only case is that, my lord, we have imposed the penalty upon the person, nothing else.
And the officers involved.
If I may just say one thing, I am appearing only in item number 47. Now, so far as that respondent is concerned, that he has been held guilty of the charges made against him. Now, he has been held guilty purely on the basis of statements issued by various persons. Now, Millard, if the basis of the order is the statement issued by different persons at different points of time, then Millard, if I am afforded the opportunity to cross-examine them, and if I can successfully discredit them, then the basis of their case will go. That is why I say that cross-examination ought to have been allowed.
Because, my lord, the statement tendered before the authority concerned, that is under the Customs Act, is admissible. That is inadmissible.
That is correct.
That is admissible. And they have not retracted the statement. At no point of time they have retracted the statement.
He is entitled to discredit or give an opportunity to say that that fellow did not tell the truth. See, in the decisions which you have relied on,
yes,
they are all with regard to the effect of an 108. 108 statement is binding on the person who gave the statement.
Yes.
The deponent, it is binding on him. He cannot say that it was obtained under fraud, etc., because the presumption, yes, he does not have a right. But he is a third party to the statement.
Now, my lord, here the question is, the statement which has been obtained from the person, that has been supplied to them at the time of issuing the show cause notice, we have given. They have given explanation to the same, whether the statement is binding on him or not. They have given the explanation to the same, and thereafter the adjudicating authority. And not only the thing is that, my lord, we are relying upon the statement, other corroborative evidences with them.
That is different.
That's why I'm saying here, my lord, not the only case that we are only relying upon the statements of the persons. We are relying upon the phone calls. We are receiving the communication before the persons, and the, my lord, the airport authorities, my lord, logbook, that will be considered by your lordship.
See, in his reply, what he has stated, I further state that the officers of SIB have taken statements of the witnesses as sacrosanct and fully relied upon the same and proceeded arbitrarily and issued the show cause notice without considering the legality, validity, propriety, and sanctity of the statement so procured. In the premises, I therefore beseech that I may be allowed to cross-examine the witness. This is his reply.
Yes.
Now you come to the adjudicating authorities' observation. Then there is an additional interim reply.
My lord, that is 217, page 217. Adjudicating authorities order is 217, lead matter. And your lordship will kindly come to page 264, that is the findings.
No, he has given an additional reply.
Yes. Initially, he has stated that I have not received all the documents, relied upon documents.
Page 194.
Yes, my lord.
He says further statements obtained from officers SIB, putting the witnesses Somnath Majmundar, Mukesh Shah, Hirmadi Chakraborty under coercion, unequivocally disclose the statements were extracted from those persons for implicating me purposely, since I was the organizing secretary of the AAEU, and I have been made a victim since I've raised my voice against high-handed so-and-so, so-and-so. I was forced to write the questions. How many persons have to be cross-examined?
My lord, they have prayed for 11 persons. Whose statement we have recorded, they are prayed for cross-examination of all the persons.
Wherever his name has been dropped,
yes,
yes, that person has to be permitted.
That is all we have asked for.
No, wait 1 second.
No. Subsequently 11.
Best way of short circuiting the matter is this. It will save a lot of time for the revenue, and it will be in the interest of revenue also.
Well, that I know, my lord, but the issue is, my lord, each and every day, my lord, this is the issue. This is the issue, my lord.
Page 264.
264. Yes, my lord. Discussion and findings.
For fifth line,
Yes.
second line, observe some of the notices of parade for cross-examination of persons who have given statement in 108. In my opinion, evidence in adjudication proceeding need not be like one in criminal cases. And finding in adjudication is based on preponderance of probabilities. Correct. Rightly so. In the present case, there are enough circumstantial evidence which provide for a reliable basis for corroborating the statement in 108. If you want to rely on 108 and it's a third party statement, you give him opportunity. If you say that dehorse 108, I have got sufficient material to hold him guilty, well and good.
On that issue, my lord, your lordship can pass the order. If we
You
want,
ignore the 108.
yes, my lord, on
He
that
will
issue.
pass for a shot.
Yes, my lord. On that issue, your lordship can.
That's the best.
Absolutely.
See, very well. Whoever has taken my name, if his statement is to be
It
taken,
will not be relied on.
very well. But
Ideal.
Millard, in that event, in my case, Millard, item number 47, Millard, may I just point out one thing? I had repeatedly, after getting the show cause notice, written to him saying, please allow me to cross-examine them.
Yes.
That is why my final reply did not get filed. And the order was passed before my.
So what we can do is.
Yes.
Uh,
I may be allowed to. put
No,
in
no,
a final reply.
all the assessees, see, all the appellants, I mean, respondents, will be directed to treat the adjudication order as a show cause notice. You give your additional reply. Wait, let me complete. You give your additional reply. And that will be adjudicated. And while adjudicating, the adjudicating officer shall not refer to any of the 108 statements where he has not been given an opportunity, because he is not being given an opportunity to cross-examine those statements, because even according to the officer, there are sufficient evidence which corroborate the statement. So dehorse the statement. If the evidence is clinching, nothing prevents him from. So you bring additional reply on record.
Very well.
Saying that the statements are inadmissible. You cannot rely. Because no cross-exam. We will make that as a part of
Your
the
lordship will make it clear.
That the order, it will be make it clear. And he will, that is the best.
Well, I am agreeable to. I am agreeable to.
Two cases, there is no cross.
Something will happen.
And if your lordship, if the department kindly make a clause pilot there too, if the department wants to reject the statement, they will provide the clause.
Yes.
That
Yes.
also be.
What more do you want?
Yes, certainly. That serves my purpose.
Mr. Maiti is so fair enough to.
Why? But I have no objection to
Please,
that.
thank you.
I'm thinking in two.
And all the matters are common impugned order.
Yes.
Common impugned order.
That is, no. Which is MAT.
MAT is, my lord.
Five.
That is the writ appeal which is traveled up. That is the
MAT
writ-
556 is the appeal by the department against the order in the writ petition.
Yes, ma'am.
Justice Basak's order.
Justice.
And the other orders are all orders of statutory
Statutory,
appeals under
yes.
130.
Yes.
2 meters there.
This will be 44 to 49.
44 to 49. Yes.
44 to 49, sir.
Well, just one thing, I am appearing only in item number 47, Millard. So I can give my consent so far as that matter is concerned. So far as the others are concerned, Millard.
No consent is recorded.
Very good.
And somebody will appear for Soumya Roy Chaudhary.
Original.
All right. In this bunch of appeals, this bunch of appeals can be divided into two categories. The first appeal, the first being MAT number 556 of 2019, which was filed by the department challenging the correctness of the order in WP number 25447 within bracket W of 2018, dated 1st February 2019. The said writ petition was filed by the respondent in MAT number 556 of 2019, challenging an order in original, original, dated September 6, 2018, passed by the adjudicating authority in exercise of its powers under the provisions of the Customs Act 1962. By the said order, penalty has been imposed on the respondent in this appeal. The primary ground on which the order of adjudication was challenged is by contending that the adjudicating authority had referred to the statements of around 11 persons recorded under section 108 of the Act. And in spite of specific request to afford an opportunity to cross-examine those persons, the adjudicating authority rejected the request and simultaneously passed the order of adjudication, which was impugned in the writ petition. Elaborate submissions have been made before the learned trade court, both by the revenue as well as the writ petitioner, and by the impugned order dated 1st February 2019, the learned writ court came to the conclusion that the respondent writ petitioner should be afforded an opportunity to cross-examine those persons from whom statements have been recorded under section 108 of the Act. Accordingly, the writ petition was disposed of by permitting the adjudicating authority to proceed with the show cause notice dated February 13, 2017 and reply thereto in accordance with the law. And the adjudicating authority will afford reasonable opportunity of cross-examination of witnesses, which the writ petitioner seeks to cross-examine, subject to the provisions of section 138 capital B of the Act. Full stop. There were other co-notices who were also imposed with penalty by the common order of adjudication dated 6th September 2018. Those co-notices did not file a writ petition, but availed the statutory remedy of appeal before the tribunal. The learned tribunal had Anjun, you give one CMA, one appeal. The learned tribunal by separate orders had followed the order passed by the learned writ court in WP 25447 within bracket W of 2018 dated 1st February 2019 and allowed the appeals and remanded the matter with the same direction as issued by the learned writ court. Aggrieved by such orders, the revenue has preferred appeals under section 130 of the Customs Act, raising the following substantial questions of law. Mighty, where is the question of this petition? Yes, sir. This is Casta 4 of 2022, page 22 and 23. There are totally 6 questions, 7 not required, 1 to 6 alone. Full stop. Since the issue involved is common and the question as to whether the respondents are entitled for an opportunity to cross-examine those persons from whom statements were recorded is also a common question in all these cases, the intra-court appeal as well as the statutory appeals filed by the revenue were heard together and are now disposed of by this common judgment and order. On several dates, the matter was heard and elaborate submissions were made by the learned senior advocate appearing for learned senior standing counsel appearing for the revenue and the learned senior advocate appearing for the respondent in MAT number 556 of 2019 and the other advocates appearing for the other respondents. The short question would be as to whether the adjudicating authority was right in refusing to grant an opportunity of cross-examination of third parties from whom statements have been recorded, which have been referred to and relied upon in the adjudication order, which was impugned in the writ petition, as well as before the learned tribunal. The adjudicating authority in the first paragraph of the order of adjudication dated September 6, 2018, has opined that evidence in adjudication proceedings need not be like the one in criminal cases, and finding in adjudication is based on preponderance of probabilities. Further, the adjudicating authority observed that in the cases on hand, there are enough circumstantial evidences which provide for reliable basis for corroboration of the statement given under section 108 of the Act. Furthermore, it is observed that the witnesses who have given statements voluntarily have not retracted their statements, and the witnesses are well conversant with facts of the case and the role of the notices/respondents. Therefore, the adjudicating authority rejected the prayer for cross-examination on the ground that that it is flimsy, rejected the prayer for cross-examination. The adjudicating authority relied upon the judgment of the Honorable Supreme Court in Kungo, KANUNGO and Company versus Collector of Customs, Calcutta and others, 1983, within bracket 13, ELT 1486, within bracket SC. As pointed out earlier, the question would be that if third-party statements are to be relied on with or without corroborative evidence, is the noticee entitled to cross-examine the said third party? As pointed out earlier, elaborate submissions have been made and voluminous compilation of judgments have been placed by the learned Senior Standing Counsel for the Revenue as well as the learned Senior Advocate for the Appellant. In our considered view, the necessity to answer the question of law which arises for consideration in these appeals may not arise on account of the peculiar facts and circumstances of the case. Admittedly, as per the view taken by the adjudicating authority, as is evident from the order of adjudication, that there are sufficient evidence available to justify the imposition of penalty on the notices. It is true that the adjudicating authority has stated that this evidence which is available corroborates the statement given by the third parties under section 108 of the Act. Thus, if according to the adjudicating authority, there is enough evidence to pin down the respondents, dehorse the statement recorded under section 108 of the Act, this court fails to understand as to why the adjudicating authority should place reliance upon the statement under section 108 of the Act. The learned Senior Advocate appearing for the respondent in MAT number Mr. Mitro appeared in
556
in MAT number 556 of 2019, submitted that there is a lot of distinction on facts. Submitted that in several of the decisions relied on by the revenue, it was cases where statements were retracted, and certain other cases where there was a direct link between the persons who had given the statements, who were also notices, as well as the other co-notices. And the case on hand is entirely different, as the notices who are respondents in these appeals are independent persons. In our view, considering various factors, more particularly the peculiar facts and circumstances of the case, and also taking note of the fact that the adjudication proceedings commenced with the issuance of the show cause notice in the year 2018, and the matter has been lingering before this court as well as before the tribunal for several years, we are of the view that without answering the substantial questions of law which have been raised by the revenue in these appeals, and workable direction can be issued whereby the question of law can be left open. At the same time, the rights of the respondent notices is protected, as well as the interest of revenue also can be protected. Thus, in that view of the matter, the appeals stand disposed of with the following order and direction. Once again, we make next. The respondents are directed to treat the order of adjudication dated 6th September 2018 as a show cause notice, and the respondents are directed to submit their additional reply, clearly pointing out that the statements recorded under section 108 of the Act cannot be relied on to frame the notices, and the respondent shall submit their additional reply on the alleged evidence which is stated to be available with the department as mentioned in the order of adjudication. The respondents are directed to submit their reply within a period of 6 weeks from the date of receipt of the server copy of this order. On receipt of the reply, the adjudicating authority is directed to afford an opportunity of personal hearing to the authorized representative of the respondents and adjudicate the case afresh. We make it clear that while adjudicating the case afresh, the adjudicating authority shall not rely upon or refer to any of the statements which have been recorded under section 108 of the Act but from third parties in which the names of the respondents have been referred to, and the adjudication shall be done based on the evidence which is stated to be available with the department, and considering the objections that the respondents will raise in their additional response directed to be submitted as above. In the event the adjudicating authority is of the view that the statement under section 108 of the Act has to be relied upon, then it goes without saying that the respondent shall be entitled to a full-fledged opportunity of cross-examining such of those persons from whom statement under section 108 of the Act has been recorded. Full stop. We once again make it clear that the substantial questions of law which have been raised by the revenue are left open, and the observations and findings rendered by the learned writ court to justify its ultimate conclusion are not to be treated as a precedent, and the legal question is left open. With the above direction, the appeal stands grateful.
My lord, your lordship has not granted time limit to adjudicate. They will file reply.
The adjudicating authority shall endeavor to complete the adjudication proceedings afresh as expeditiously as possible, preferably within a period of 4 months from the date on which the personal hearing is concluded. Grateful.
ভালো চাইনি এখন চাইবে না
সেটা আবার যদি চাই সেখানে গিয়ে
চাইলে যাবে দেবে। আমরা তো প্রসিডিং তো রিলাই করছি না, ওদের স্টেটমেন্ট তো রিলাই করছি।
But
For-
this problem for our ears, we have to take. This will put to last. And the substantial questions are left open. Last line.
Which item? MAT.
On item B.
With the consent of the learned advocates appearing for the respective parties, MAT 556 of 2019 is treated as on the dates list, as on the supplementary list. The same is also disposed of.
For hearing item number 50,
My lord, this is my appeal, my lord, challenging the order of the tribunal we have preferred. Your lordship kindly see your lordship's last order, that is 25th July 2022.
Deepnath Chaudhary. He is Mr. Deepnath Chaudhary. Respond.
এতে 16-তে যাবে এখানে
Yes.
But on that date, your lordship's observation is the matter should be remanded to tribunal. So your lordship either can remand or can admit the appeal and direct me to file the paper book. It is not the paper book, my lord. It is the documents your lordship has directed to an it is compilation.
But respondent, you are appearing, sir.
I'll be here on.
But I think tribunal absolutely perfunctory order. Let it go back to the tribunal.
My lord, the question that whether the issues arguments based on section 123 of the Customs Act, it was very much there from the initiation of the proceedings, from the stage of even reply to the show cause notice, my lord. I will demonstrate.
All
that.
right. Then what you do is you file your paper book.
My lord.
Sir, Anjan, that round memorandum, question of law. Mr. Maiti, can you give your stay application?
Stay application, yes, ma'am.
Oh, your copy. The appeal. See, sir, that interim order. We can dispose of the order granted on 25th July 2022 shall continue till the disposal of the appeal, and the same is made absolute. In the main appeal,
My lord, this may be the question of law, my lord. That is not. I have subsequently formulated, my lord. That is not in this.
the appeal is admitted on the following substantial questions of
yes,
then informal paper.
In
that order, the compilation of documents filed with the revenue is taken on.
Okay.
50 and 51 same, is it? No.
Yes, 50 and 51 is same.
Same.
item number 52,
Oh, no.
না না আপনার হয়ে গেল তো এডমিট করেছি
Appeal question. Paper.
None appears for the parties. Let the matter be listed in the monthly list of combined monthly list of July. Please stand up one second.
Item number 33 of monthly list.
Mr. Mukherjee. Mr. Mukherjee.
Sorry, my lord, I could.
No problem. In the another matter, we dismissed the appeal.
Yes, my lord,
He said that if he has got some document, it's basically a civil matter.
my lord.
He has to file.
My lord, this matter relates to in respect of
This is passed
135.
over matter.
Yes, 135 and 126 of the Electricity Act. My lord, only thing, my lord, Mr. Shumon Ghosh is leading me in this matter. My lord, I will only pray if my lord may kindly, my lord may take it up any day next week, my lord. Any day next week, my lord. 33 and 34. One is the review and another is the appeal.
Next Tuesday.
Any day next week, my lord. He has requested, my lord, if my lord may kindly.
No, it's Wednesday. 14th.
What is the review application?
Lord, the review file for there was some mistake in the original order.
This is review. No, review of which order you are seeking?
The order
Original
dated,
order.
order
Original
dated
order.
4th of April 2022, which is the original order upon which the appeal has been preferred.
There are two appeals is before your lordships. One
Yes.
is the original order and the review order.
Okay. So you went before the learned Red Court by way of review application that was dismissed. So two appeals.
Yes, yes. Against to the
So there are two orders.
There are
One
two orders.
in the main writ petition, one in the. Sister. So when do you want it?
Any day next week, and any day subjects to
Next Wednesday.
as your lordship.
Yes, make you are appearing.
No, in this matter, I'm the last matter, my lord. Only to the next matter, I'm sorry, my lord, interrupting your lordship, my lord. The order will be confined only to the respondents who are before this honorable court, because who have not challenged this order, that will not binding up.
In that order, one line. It is further made clear that this order shall inure in favor of the respondents who are before this court and not in respect of any other persons who have not questioned the order, the adjudication order dated 6 September 2018, either before this court or before the learned tribe.
I'm much obliged. Sorry to disturb your lordship, kindly excuse me, my lord.
At the request of this one, sir, item 3334, we have heard so and so. At the request of the learned advocate for the respondent, list next Wednesday.
As well. But 33 and 34 both. I'm grateful, man.
Dinner time नहीं होना finish करेगा
4 months more than me.
14th. List over. Yes. I'm to brief to next week this week.
14 तारीख state
One day is 2 half days. So just inform your proposal to worship. Indication of so that let's say the indication of the other side. Both sides are present. Oh, we have passed this issue.
that's everything so the steps so the people so
Rajula যাওয়াটা ঠিক
স্টিল কথাবার্তা বলছি না হয়ে গেছে
Then we'll come around to see what is okay.
Okay. After completion, after completion, we are
Ten.
Appellate side, day list, item number 1.
I appeal for the, yes, my lord.
What was the yesterday's appeal number,
Yesterday's
writ petition number?
4567 or something, my lord, subject to, my lord,
Please take note. This writ petition has been filed by the employer challenging the action initiated by the respondent, Employees Provident Fund Organization. More or less identical relief, no. For the same subject matter, the writ petitioner had filed another writ petition in WPA 4597 of 2020. And the said writ petition was dismissed by order dated 6/6/2023. The operative portion of the order reads as follows. We can quote that relevant portion of the order from that yesterday's matter. Following the above order, the writ petition stands dismissed on the same lines.
and all interim orders vacated, my lord.
All interim orders. Everything dismissed.
Great, my lord.
Dismissal of interim orders cannot be.
Next.
Item number 2. Yes, my lord. In this matter, I am appearing for the petition. Yesterday, I have mentioned the matter. I have already noticed for mentioning to the other side. There is Mr. Omritolal Chatterjee, advocate, care of Mr. Nilotpal Chatterjee. Two advocates appear on behalf of this. Nobody is there.
But today there is a resolution.
Yes, today the one announcement in the bar association. Therefore, I do not want to proceed with the matter. Kindly fixed any day.
Tomorrow.
Tomorrow.
It will come. Can it come tomorrow? So
I'm grateful.
We have heard the learned advocate for the petitioner. None appears for the respondent state. List tomorrow.
I'm highly grateful to you. Item number 3.
The file need not be given. We just call the matters.
Item number 4.
Extension.
4, my lord. I am appearing on behalf of the appellant, my lord.
Item number 5.
Availability of service.
No one.
Tomorrow.
Let it remain in the list because it's upgraded matter.
5 and 6. Sir, I don't collect this matter.
5 and 6.
Item number 6. Item number 7.
Tomorrow.
Item 8. 9. 10.
10, my lord, I am appealing for the appellant.
11. 12. 13. 14. 15. 16. 17 to 44.
Yes, sir.
May it please your lordship. I am praying these matters should be taken up on Monday because my flight is today at tomorrow. I will not be available because of
there is already an interim order in this.
the already interim order. So any date convenient to your lordship, since interim order is there, so advocates will not be in hurry. Only the other side will be in a hurry that it should be disposed of.
No, we'll fix it in July.
July, very well.
17 to 29. 17 to 44. We have heard the learned advocates for the parties. The interim order has already been granted and the same is continuing. Let the matters appear in the combined monthly list of July 2023 and thereafter a date will be fixed for hearing of the appeal.
I am highly grateful to my lords.
Yes.
I don't know, 45. 46. 47. 48. 49.
I appear for the respondent number 1 tomorrow.
50, I don't know, 51 and 52, 53, 54.
So tomorrow the whole list. Tomorrow full day. Appellate. So no problem.
My lord, is it your lordship's pleasure to take up the item number 8, my lord?
8.
8. An old man is 71 years, is suffering because in his house he can.
Respondent is available, sir.
No, my lord, I do not think the respondent may come today.
Tomorrow it will be.
Very well, my lord.
This list will come tomorrow. As
Very well,
it
my
is.
lord. An old man is suffering. He cannot enter into in house. The cars are parked in a place 5 Dent Mission Row, Khidirpur area, and he is the Mojo family, suffering immensely.
And who's parking those cars?
Parking means the car are two-wheelers, and my lord, there are also, my lord, hawkers who are deliberately sitting in front of the house. And my lord, I have also judgments. I will show to your lordships.
Some photographs you have got.
Yes, yes, I have. I have taken the photographs.
And
well, I was thinking, my lord, I was becoming interested to show to your lordship at least 2 or 3 pages today.
Now, what happened to your writ petition?
My lord, the writ petition has been my lord, disposed of on the ground that his lordship cannot pass any effective order because the police cannot be possibly directed, nor the KMC can be directed.
Why?
Well, I do not know, my lord. There is section.
No. Suppose your ingress and egress to the property
is
affected.
Heavily affected, my lord.
No.
He is an advocate. His son is an advocate. His brother is a retired officer, army officer. They are occupying the house for 40, 50 years and they cannot. I'm surprised, my lord. Everybody has a right of residence in any part of India. Your lordship knows, my lord, Article 19(1)(e) and then Article 21. But I'm totally surprised. Well, your lordship can pass a little bit order. Well, we'll kindly look at the impugned order. Well, this part, Mr. Sushil Kumar Mojo is suffering immense. Is annexed to.
Mr. Chatterjee is here. Government Council.
Well, this order, at least this order, your lordship will only look this order. My mind will be satisfied. The order is annexed to the memo of appeal. Unfortunately, my junior did not annex it in the stay petition.
Oh, this is proper. Petitioner's chamber is an extremely busy market in the of Congress, frequented through. Problem like this face blame cannot be addressed either by KMC or police. But if there something has to be done.
These are not being done, my lord. A person cannot enter into a hospital. He cannot go even to the hospital because the ambulance.
Have you got color photographs?
Yes, my lord. Yes, and it's colored photographs is at page 29 onwards.
You have given us only black and white.
No, I'm very sorry. Sorry, man. Very, very sorry. Kindly dinner, please. 29 page. Mal, I'm very, very sorry. I tender the apology, unconditional apology.
No problem.
You are doing wrong.
Which is the house of the writ petition?
House is house to exactly.
Green Plaza.
Yeah, Green Plaza, beside Green Plaza.
There's opposite Green Plaza.
Opposite Green Plaza.
Yes.
Chandani Enterprises.
My lord will kindly look below 35, 36 page numbers. The senior officer says, police officer says, yes, some protection is necessary. But the Watganj police will not assist it. Well, I am not naming anything. Well, other community, I don't want to. There are. Mal will kindly look once below 35, 36. Mal will kindly look 35, 36.
This is all. Sir, so far as shops are concerned, if suppose the shop owner has a two-wheeler, he may park his two-wheeler. Somebody visiting the shop or customers may come. But hawkers, something can be done.
My lord, hawkers, my lord, there is decision which says hawkers cannot come to the residential place. I think which had been
You give this.
Yes, my lord, I will show to you, lordship. I have brought it.
But unfortunately, there is no advocate for the.
I know, my lord, but my lord, will kindly
police.
look at the thing. My lord, will kindly once see, my lord, paragraph 14 of this judgment. Kindly, my lord, once see, your lordship, regarding the hawkers, what has been said by the Supreme Court. Paragraph 14.
We can do one thing.
Yes.
We'll issue a direction to the concerned police,
My lord.
referring to this decision, etc. And show cause as to why they are not taking action, etc. Ask them to file a report by next week.
I'm extremely grateful.
And let the police be present.
And my lord will kindly consider also page 35 and 36, where the police officers, higher police officer says yes, safe protection is necessary. Your lordship are totally, my lord, whatever fallen from your lordship are correct.
35, 36.
Page 35 and 36.
We have heard Mr. So-and-so learned advocate for the appellant. All right, tomorrow we'll pass this order.
My lord.
Because the resolution is there.
No, my lord, I will come. I will come tomorrow. I was just interested to show to your lordship the things which is going on. Well, let the judgment copy be with your lordship.
Yes. And if possible,
My lord, we will be, can I get the leave to give the color photograph tomorrow?
yes, that's what we are trying to. No, not this today. You ask him to take photos today evening.
Okay.
It's only 2:45.
Take the photographs
Today evening and make a printout.
Absolutely.
Clearly showing where the petitioner's property is, and the alignment of the road,
and
how the hawkers
also showing the frontal portion of the house.
Yes.
Have you understood?
He's what is it? Name board of the advocate should be there.
Advocate should be there.
Yes. Yes.
Well, in fact, I'm telling you, lordship, my lord, he is the junior member of the Mojo family. He has become the advocate on record, but he comes regularly in the court. My lord, he is being threatened by the police. My lord, I'm not trying to name anybody, but other community means your lordship knows, my lord. I do not want to say. My lord, one of them wanted to purchase the house in 2006. And he prepares the different types of papers. I had to go to the BLLR to make it to make it corrected. So, my lord, there are many things, my lord, I don't want to go into that. Lots of simple protection, my lord, that I will be able to come out and I will be.
No. Now they have said that that area has to be declared as a no parking zone.
No parking zone. No parking zone.
No, deputy commissioner has said so.
Yes.
But that is not being enforced.
Not enforced.
This is not a notified area.
It's not a notified.
No, my lord. Not a notified area. At least in front of my house. And because the DC himself says that I will see how the no parking could be imposed there. That letters are there at page 35 and 36. I'm coming tomorrow.
Please inform the government council. The matter was heard, but the court has not passed any orders because there is a resolution. Matter will be heard tomorrow.
I'm grateful.
Same position it will retain. Item 2 will become item 1. That is correct. From 4, you should not add equity. You will add. Fresh matter where it will come. Correct. Before upgradation, you add. Before this heading, you can add correction or addition. But between this and this, you don't add. Don't disturb this list. Please explain. But tomorrow don't upgrade anymore. Because we are not able to take upgrade. No upgradation. Tomorrow same list.
Item number 17, my lord.
17.
17 to 44, my lord. My lord, actually, in view of the resolution, my lord, I was not appearing today. These are my appeals, my lord. These are my appeals on behalf of the licensees, my lord. On my lord recollects, this is a licensee where the disconnection.
We fixed it in July.
My lord, there's extreme urgency, my lord, in this matter. If my lord kindly takes it up on
No,
5th.
no, we can't, sir.
My lord, in view of the resolution, my lord, I was not able to appear today, my lord, because of the fact.
But we are sitting, no, you are appearing.
My lord.
We are hearing you. We can't do that because there are as many as 40 requests have come to upgrade 2021.
My lord, I'm not praying for upgradation. My lord, it can appear on 22nd of June, my lord, because my lord, I'm led by the learned advocate general in this matter, my lord.
Advocate general is coming only on 18th. He'll be a bit tired.
My lord, on
So
14th.
he immediately cannot.
My lord, I presume on 14th of June he is returning. My lord, will kindly, my lord.
No, because.
My lord, 24th of June, my lord, will kindly keeps it on 24th of.
Jet lag, yes.
My lord, 14th of June he is returning. My lord, 24th of June, my lord, will kindly.
If you come in July, definitely we will take it. Please.
My lord, will kindly keep it at top of the list on July 1st. My lord.
That we will do.
My lord, will kindly do that because because lot of consumers, my lord, are drifting away. My lord, they're not paying also.
Now you are giving free supply. Today in the newspaper I read.
No, my lord.
Even for tenants.
No, my lord, that is a different licensee. But this is a licensee, my lord, concerning, my lord, where there are huge crores of areas. They're not paying in the garb of an order, my lord. My lord, will kindly keep it on last week of June, my lord. Last week of June, my lord.
We come in first week of July, we will definitely do.
My lord, at the top, my lord, will kindly direct my lord's officers, my lord. My lord, at the top, my lord, will kindly, my lord, directs.
It will be above this. It will be above here.
My lord, my lord, there's extreme urgency in this matter because
we fully appreciate because we heard all of you once, twice, thrice, 4 times. We have passed an interim order. We are aware of the subject matter. Please accommodate us also.
My lord, definitely.
Individuals are coming, saying that today somebody says a very sick person, this is happening, that's happening. My case is 894. Please upgrade. So Lordship is every day evening. He's got so much a bunch of papers.
No, my lord.
He takes the file painstakingly. He goes through the matter. Then it is today you see 4 matter upgrade. So kindly, we are also trying to balance.
My lord, I'm humbly bowing down to my lord. My lord, last week of June, my lord will also do, my lord.
First week of July it will come. Thank you.
Deeply obliged, my lord.